Well, hello there. Thank you once again for joining me right here on this live stream session. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you've come to the right place at the right time to learn about your employment law rights. This is what this session is all about. It's about informing and educating you about workplace rights so that you know what to do if you're facing a workplace issue. You know what the law says, you'll know what the law does to protect you, and how to respond in a difficult situation. Again, I'm Lior Samfiru. I'm one of the partners of Samfiru Tumarkin LLP. You'll find the firm across Ontario, BC, and Alberta. And if you're facing a workplace issue, if you're dealing with a workplace problem, if your job is being threatened, if you lost your job, if your employer is not treating you properly, you name it, you're now at the right place to get some answers and some help and some guidance about what to do, what to say, and how to respond. Again, Lior Samfiru, that's me, the employment lawyer. This is a live session where you get to ask questions. You get to ask me about your situation. You get to make sure that you get solutions. So listening is fantastic. You can listen to me and you'll learn a lot, I promise. Well, you know what's better? If you type in your question, you hit enter, and I'll read it and I'll answer your question. This is a back and forth between you and I, so let's make sure that happens. Now, before we start today, let me give you some other contact information. If you want to connect with me off live stream, off social media, you want to have a private chat, very, very easy to do. All you got to do is go to employmentlawyer.ca. Again, employmentlawyer.ca. And when you go to employmentlawyer.ca, you'll get all the contact information that you need. Phone number, email address, it's right there for you. So use it and make sure that you get that information right there. So easy to connect with me. But right now, I'm live with you right here. I see a question came in. I'm going to start answering. You have so much time right now to ask your question as well. Don't be bashful. I promise there's no such thing as bad questions. There's only answers. There's only solutions and help. So right now, ask your question. Let's make this happen. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Let's start answering some questions. All right, first question right out of the gate today. That's from PJ. My friend in his 40s recently got laid off after almost 5 years from a small to mid-sized company. He's been given 10-week severance, no notice. Is this enough? Well, no, that's not even close to being enough. The main factors that go into assessing how much severance you need is your age, your position, and the length of your employment. So age, position, length of your employment. The longer you work, the older you are, and the more senior a position you have, the greater the entitlements. Okay, so for him, after 5 years in his 40s, I don't know the type of job, but he'll likely be looking at easily 6 months severance. 6 months. 6 months is 26 weeks, right? He's been offered 10 weeks. So that's not even close. He's owed more, and that's what we call a wrongful dismissal. A wrongful dismissal simply is a situation where you've been let go and you have not been offered your proper severance. So he's been wrongfully dismissed, your friend, because he was offered 10 weeks when he should be owed 6 months, 26 weeks. So he needs to call me. I can help them get that resolved. That is a very, very common situation. The vast majority, well over 90% of people that contact us after they lose their job, that severance offer that they've received, not even close. So if you lost your job, there's a 90% chance plus that whatever you've been offered, not close, not what you're owed much, much more. So PJ, you've taken the first step. You asked me the question right here. The next step is to have your colleague or your friend contact me through employmentlawyer.ca. Again, employmentlawyer.ca, the way to connect with me. Phone number, email is all right there. See the address right there, employmentlawyer.ca. All right. So now that we know that, let's continue answering some more questions. By the way, if you just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here with you and for you just to answer your questions about employment rights ask your question. Don't be bashful. There's no such bad questions at all. If you want to talk about your vacation pay issue, let's talk about that. If you want to talk about your wrongful dismissal, your constructive dismissal, discrimination, being bullied, harassed, medical leaves, you name it, let's talk about that. I can answer all those questions, so let's make it happen. And our next question today comes from YouTube, and that's from Jamin. I took a parental leave, and when I came back, my shift had been changed. Usual start time was 8 a.m., and now they have me on at 12 p.m. to 8 p.m. Is this legal? Not legal. So this would not be legal even if you did not take a parental leave. An employer does not have a right to make significant changes to terms of employment. And taking you from an 8 to 5 to a 12 to 8, that's a huge change. That's a very big deal. And that would result in what we call a constructive dismissal. In other words, by changing the terms of your employment that way, the company is now giving you the ability to say, no, I'm not okay with that. I'm going to consider that to be a termination and get my full severance. That's what a constructive dismissal is. Your employer is not allowed to make those changes. Your situation, though, is even worse or more illegal, because your employer, when you come back from parental leave, your employer has to give you back the same job on the same terms. This employer didn't do that. So that's a violation of the Employment Standards Act. It could potentially also be a violation of the Human Rights Code, completely and utterly illegal. So the last thing then to think about, Jamin, is what do you ultimately want here? Do you just want your employer to back off and give you back your old shift? I can make that happen. Once they hear from me, trust me, they'll back off completely. They'll give you what you want. Or do you want to say, no, I'm not okay with this. I'm not going to accept this. And I am going to treat this as a termination. If you want to do that, I can help you with that as well. So reach out to me, Jamin. The best way to do that, employmentlawyer.ca. Again, employmentlawyer.ca. Contact information, phone number, email address, etc. It's all right there. Fantastic question. Really great question. And I think you at home as well, you can see how easy it is to ask me a question. I'm Lior Samfiru, the employment lawyer. And Jamin had a question. I gave him the information, tell him what it means, what to do, what the rights are, and what the options are. So easy. You can do the exact same thing by typing in your question right now. It's going to magically pop up on my screen. I'll read it, and I'll give you my answer. Very, very simple. If you're going to ask a question, man, let's do that right now. Don't wait till the end of the session, and then I may be done, and you'll try to type in your question, and I won't see it. We'll run out of time. Don't let that happen. So let's continue answering question, and I'm going to continue right now. I see some questions popping up. I will get to all of them, all right? Ask yours too. Ned has our next question. My boss gave me a layoff on August the 5th and filed a record of employment with expected recall date of September the 29th. He called me on September the 30th. He recalled me on September the 30th. He still owes me a month of salary. I don't see favorable conditions to come back because of that. I refused the recall, and now he says I quit. What can I do? Very good question. In most cases, your employer does not have a right to put you on a temporary layoff. You heard that correctly. Your employer, in most cases, does not have a right to put you on a temporary layoff. So if your employer does put you on a temporary layoff, that would give you the right to consider that a termination and to force the company to pay you severance. That's true, even though the company was planning on calling you back to work at some point. Doesn't matter. Your employer doesn't have a right to just say, I'm going to stop paying you for a bunch of time. Doesn't work that way. So, Ned, here's what this means. You don't have to go back to work. You can consider that a termination and get your full severance. Now, I don't know how long you've worked, and I don't know the job you were doing or your age, so I can't tell you right here how much severance you're owed. I want you to connect with me, okay, off air, so we can talk about that, assess how much you're owed, and get you what you're owed. But for everyone out there as well, if you're put on a temporary layoff, well, you have a choice. You can accept that temporary layoff and sit at home and wait to see what happens. Or you don't have to do that. You can consider that then a termination. I'm not waiting. I'm going to get my severance and move on to a different job. If that's what you want to do, call me. Keep in mind that if you accept the temporary layoff and go back to work, you give the company the right to do it again. Okay, very bad thing. So that helps. Hopefully, any follow-up questions, ask me. Again, I'm still here, and I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. More questions have come in. I'm going to ask them, or I'm not going to ask them. I'm going to answer them. I think that's better. And you have time to ask yours as well. So make that happen. All right. Next question from Block Boy. I got a letter of expectation back to back less than a month. I asked for a volunteer mutual separation, asking for severance and benefits as I felt the relationship went bad with my manager. You haven't asked a question, Block Boy. There's no question in your comment here, but here's what I will say to you. You can certainly ask for a separation package. Your employer doesn't have to give that to you, okay? So you can't force the company to decide to let you go with severance. You can quit, but if you quit, you're not going to get severance. Now, the question also becomes whether the letter of expectation that you got, I think you probably mean some sort of a performance review or a performance improvement plan. Is that completely off base? Has now a poison work environment been created? If your employer is picking on you and treating you badly and making demands that are nonsense just to kind of push you out, you may be able to consider that a termination and force them to pay you severance. But I would obviously need to know, what have they done to you? Why is it unreasonable? How did they create that poison work environment? If that doesn't exist, that poison work environment, you certainly can't force the company to let you go. If they do let you go in the future, of course, you're owed severance. So, Block Boy, if you want to talk about whether or not this is a situation where there is that poison work environment that allows you to consider this a termination, let's talk. You can reach me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. The address is right there. And I'm happy to sit down, go over it in detail, and tell you exactly what this means and what you can do. Okay, so you know what to do now. Reach me then. If you're just connecting and joining us just now, very happy to have you here. Thank you for being here. I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And what I've been doing and what I'm going to continue doing is answering your questions about employment law, workplace rights, live, right here, right now. You have the ability to ask your question. I see questions that have come in. I'm going to answer all of them, but I want your question. I'm only going to be here for another 17, 18 minutes or so. So you still have time, but that time's going to run out eventually, right? So ask your question right now. All right, Mitchell has our next question. I was late for a few shifts at my call center job. They let me go with cause, no discussion or anything. Am I able to get severance? The short answer, Mitchell, is yes, absolutely. It is very, very difficult to terminate for cause, okay? To deprive you of severance and terminate you for cause, you would have had to do something really, really bad. And being late a few times, that may not be a good thing. It's not a good thing. But that does not mean that they can impose the worst penalty on you, which is a termination for cause. Now, here's how they could potentially have done that. Let's say you were late one time, they gave you a warning, you better not be late again. The next time you were late, they said, no, we warned you, we're warning you again. Hey man, don't be late. You were late again. Then they come back and say, this is going to be your final warning. If you are late again, we're going to have to terminate your employment. You ignore that, you come back late again, maybe then they can terminate you for cause. And it depends how late you were. If it's 2 minutes, no. If it's an hour and a half, it's very different. But they would have had to do a very, to put in the work. They would have had to do that homework and paper it and give you a warning and give you a final warning in writing for them to even be any position to terminate for cause. So unless they've done all that properly, Mitchell, this is a wrongful dismissal and you are owed severance. So what I want you to do, of course, is I want you to connect with me off live stream, off social media, so that we can have a private chat. Very, very easy to do that. All you have to do is go to employmentlawyer.ca. See that address on the screen, employmentlawyer.ca. We can connect by phone, by email, go over all the details. But there's an important reminder there for everyone. It is very difficult to terminate for cause. It's reserved for the worst offenders, kind of like capital punishment. You don't get the capital punishment because you did something wrong. You did it because you committed the worst offense. Same thing with the termination for cause. That can only happen if you're guilty of something very severe. Okay, so otherwise you'll get your full severance. All right, Mitchell, thank you for that. And you as well, thank you for your questions. If you're just joining, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And I want to get your questions as well. More have come in. Thank you for that. You're keeping me busy. Keep me even busier. Let's make sure that you have answers today for everything so that you can feel better, sleep better, and make sure that your rights are protected. All right, Alex has our next question. Alex is joining us from Reddit. My employer recently installed monitoring software on our work laptops that tracks keystrokes and screenshots without informing us. I only found out from IT. Are they allowed to do this without consent or notice? So generally speaking, if you're using a work computer, there's no real expectation of privacy because it's someone else's equipment that you're using. It's not yours, it's someone else's. So the law says in that situation, they're allowed to monitor what happens on their equipment. So probably not a nice thing at all to do it that way without informing you, but legally, they can monitor what happens on their devices. Now, if you're using your own computer and they install on your computer, no, can't do that. But if it's their computer, their equipment, they're allowed to monitor what happens on that device. So be mindful of that. If you don't want the company to see what you're doing, don't do it. Okay? Hopefully that makes sense, Alex. Any follow-up questions? I'm right here. So by all means, ask away. Thank you for that. By the way, I'm going to continue answering questions. You have time. Ask your question to get an answer from me, Lior Samfiru, the employment lawyer. Jillian has our next question. I was asked to move to a new location and given a reimbursement for the expense. They just eliminated my role from the company and are asking for me to reimburse this. Can they do that? No. The only way they could do that is if at the time they gave you a reimbursement, you signed something with them saying that you will reimburse them if the position is eliminated. If you signed something agreeing to that in advance, then yes. If you did not sign, then the answer is absolutely not. But here's the thing, Jillian. I suspect that there's a bigger issue here that you should be thinking about, and that is the issue of severance. If they've eliminated your position and now you're out of a job, you're owed severance. And I can almost guarantee you that whatever you've been offered or will be offered is a lot less than what you are actually owed. Okay? You're probably owed a heck of a lot more because that's true for most people. So yes, they can get that reimbursement, but they have to pay you a full severance. I want to talk to you. I want to properly assess what you're owed. By the way, I can give you an assessment right now as well. But if you want to tell me how old you are and how long you've worked in the job, I'll give you an assessment right now. By the way, if you want to find out how much severance you're owed, I'm going to give you the tool to do that. You can do that right now in seconds for free. If you want to know what is the proper severance amount for you, all you have to do is go to pocketemploymentlawyer.ca. The address is right there, pocketemploymentlawyer.ca. And when you go there, click on the severance calculator. When you click on the severance calculator, you're right there. Answer a few questions, and it's going to tell you if you're owed 6 months severance, 10 months, 24 months. It's free. It's anonymous. It's accurate and very, very easy to use. It takes seconds, and you get that assessment. Doesn't matter if you are someone that's worked for many years or just started. If you're old or young, works just the same. By the way, it's not a week per year of service. It's not 2 weeks per year of service. It's a heck of a lot more for most people. So check it out again, pocketemploymentlawyer.ca. Use the severance calculator. By the way, Jillian, you can do that right now and connect with me so I can help you get that severance that you're owed, okay? So it's not just about the reimbursement. The real issue, I suspect, is the severance issue, okay? So thank you for that question, Jillian, and happy to help you get what you're owed and also to deal with that reimbursement issue. If you're joining us for the last 10 or so minutes, thank you for being here. I'm Lior Samfiru, the employment lawyer, answering your questions live. I see some more questions have come in. I am going to answer them, but I want your question as well. You still have time. If you ask a question right now, I promise you, you will get an answer on this session before we're all done today. Okay, so don't be bashful. You haven't missed the boat. It's not too late. Ask your question. Okay, Bob. Bob has our next question. Employer statement from employer was not fact-based while I provided documents proving my claim. How do I know whether I have a strong evidence-based case that won't be dismissed? Well, you haven't told me what case. Who did you submit it to your employer, to the court, to a tribunal? So you haven't told me anything about your situation. The best thing is, if you have a legal case, is not to try to do it on your own. Okay. It's an unfair fight if you try to deal with something on your own without proper professional legal representation, legal support. Okay, so but again, you haven't told me anything about your matter, where you submitted to who and why. So I really can't answer that. Feel free to type in a follow-up, or best advice, reach out to me through employmentlawyer.ca so we can have a private chat. I'd be happy to connect with you. Again, employmentlawyer.ca, phone number, email address, it's all right there. All right, let's see here. Brittany has our next question. My father works a somewhat physical job. He recently had a stroke, and his employer is implying that he probably won't be able to come back and he should resign out of respect. What should he do? What are his rights? First of all, it's not up to your employer to decide or even say whether he will be able to come back or won't be able to come back. That's up to your father, or most specifically, your father's doctor. The doctor is the only one that can say, can he work and on what basis? He absolutely should not resign. Here's what's going to happen. Either your father is not going to be able to come back to work at all in any capacity, but we probably won't know that for a while. Or maybe he can come back to work, no problem, old job, everything is fine. Or maybe he can come back to work on some modified basis. An employer has an obligation to accommodate. So if your doctor or your father's doctor provides a letter that says he can come back to work, but he can't lift more than 50 pounds and he can't stand for more than 30 minutes, whatever the limitations are, your employer, the employer here, has to accommodate. It's not up to them. They can't say no. That may even mean that they have to find them an office job if that's the accommodation that the doctor says he needs. That duty, that obligation to accommodate is a very, very serious one. Okay, an employer is not allowed to ignore it. So for now, your father has to follow his doctor's advice. He can be off as long as needed. Once he's ready to come back to work, either with or without limitations. If his employer won't cooperate, have him call me right away and I will help him. Absolutely not resign. Stay off as long as you need to. Follow your doctor's advice and come back with that doctor's note. Hopefully that makes sense, Brittany. Any follow-up questions, ask them, or best advice, reach out to me, or your dad can reach out to me through employmentlawyer.ca so we can have a chat, and I'll be more than happy to help and support. Don't be bullied. Don't let your dad be bullied by the employer. Resigning here is absolute nonsense. Thanks for that question. I appreciate it. All right, fantastic. By the way, if you're joining us for the last few minutes, I'm Lior Samfiru, the employment lawyer. I've been answering questions live. I want your question. You can still get a question in under the wire here and get an answer from me, so please make that happen. Just like Priya has a question. I've been working as an independent contractor for over a year, but I work full-time hours. I use the company tools and report to a manager. I'm wondering if I've been misclassified and what rights I may be missing as a result. Yeah, you obviously have been misclassified. This is a very common situation where someone works quote unquote as a contractor, but they are really an employee. Listen, if you look like an employee and act like an employee, you're an employee. And it doesn't matter what you call yourself or what the company that you work for calls you. So in this case, full-time hours, uses the company tools, that reports to someone at the company. This person, Priya, you couldn't be more of an employee if you've tried. You've been misclassified. One of the issues here is that you've probably been filing your taxes wrong. You've got to keep that in mind. If you're an employee, you don't get certain deductions in terms of what you're missing: vacation pay, overtime pay, minimum wage, holiday pay, all those things. And of course, if you lose your job, you're going to be owed severance as an employee. That severance can be as much as 24 months, depending on the usual factors. So very, very important. You've been misclassified, very common. Okay. So you can decide, do you do something about this now, or do you not do anything? And if and when you're let go, we deal with it then to make sure you get severance. Up to you. Happy to connect with you if you need help. Employmentlawyer.ca to do that. Okay. Again, employmentlawyer.ca. All right, let's continue. Let's see if we can get some more questions answered. Nicholas has our next question. I was in an accident while in a company vehicle. It was deemed no fault, but my employer says they will need to take money out of my pay. Shouldn't that go through insurance? Can they dock me? No, they're not allowed to dock you. If you get into an accident in the course of your employment and you haven't done anything crazy to cause that accident, they cannot dock your pay. Now, if you signed an employment agreement at some point, giving them the right to dock your pay, in those situations, they may be able to do that. I highly doubt that you ever sign an employment agreement that says that. So no, they're not allowed to dock your pay. In fact, doing that would be a breach of the Employment Standards Act, not legal at all. So tell them no. If they do it or threaten you, let me know. Once they hear from me, they'll say, oh, no, of course, no, it's a big mistake. We're not docking anything. Okay, they're not allowed to do that. Regardless of the insurance situation, they're simply not allowed to dock your pay in this case. So Nicholas, you know how to reach me, employmentlawyer.ca, but certainly keep in mind they're not allowed to do that. All right, let's see here. We'll see if we can take one or two more questions. By the way, guys, thank you for the questions. If you're kind of watching towards the end of the session and wondering who I am, I'm Lior Samfiru, the employment lawyer, Samfiru Tumarkin LLP. I'm here. You can see me on TV and radio as well, and learn much more about employment law. Right now, I'm still live answering questions. And let's see. The next question comes to me from Yelena. I've been working as a manager/supervisor for the last 8 months. My employer is now saying that it wasn't permanent, and he wants me to move to a sales role so he can hire his cousin for my role. Can he do this? Well, can he do it? Yes, but it gives you the right to consider that a termination and get severance. So it's not legal. Your employer can't just demote you. There's no such thing as the ability to demote you outside of to be not a manager anymore. So ultimately what this means is that you can accept this, or you could consider this a termination. You don't have to take that lower position. You can, or you can consider that a termination and force them to pay you severance. You can't physically stop them from doing what they're doing, okay? But what you can do is consider that a termination. Of course, if that's what you want to do, call me and I'll help you do that. In fact, don't say no at all without speaking to me first. You can reach me through employmentlawyer.ca. Thank you for that question, Elena. Let's take one last question, and that's from Nikki. Nikki says, myself and my 2 daughters have a case together involving employment. Since they moved in with her father, my ex-husband, there is some committing business fraud here. Okay, North Carolina. So you're in the U.S., can't help you. Canada only. So Yelena says, I've been there for 5 years. I'm unhappy about the nepotism. I agree. But ultimately, you can't stop them from doing what they're doing. It's just about severance if you choose to go that way. Okay? Not nice what they're doing, maybe even unethical. But from a legal standpoint, it comes down to severance. Thank you for that, Yelena. I think that's the time we have for today, everyone. Really appreciate the time, the questions, the participation. You make this session so much better. Thank you for being here. And as always, you can reach me now that this session is done. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. We can connect there, phone, email, whatever you need. It's right there. So don't be bashful. I'll be back soon. So will my colleagues. Don't wait, though, for that. If you need help, your legal rights should not wait. Go to employmentlawyer.ca right now. I'm Lior Samfiru. Thank you so much for being here with me today. We'll see you all again soon. Take care.